Yeah. On this point, Fredrickson's Claim 7 ad hominem argument collapses once you look at what he himself put into the case. Let's be blunt and clean about it. Number 1. Claim 7 is not ad hominem in this context. Ad hominem is irrelevant only when character is not at issue. Here, he made it an issue. He affirmatively injected his registration status into the lawsuit, claimed retaliatory enforcement interfered with compliance, alleged constitutional harm tied to registry obligations. Once he does that, the court is entitled to examine his compliance history, his credibility, whether alleged barriers were actually self-created. The quote you referenced, open quote, "He blamed the victim, failed classes," is a risk. Close quote is not rhetoric. It is a judicial finding, on the record, from a hearing he initiated, resulting in a denial of relief. That is not an insult. That is adverse factual context. Number 2, the pattern cuts against him, not for him. He argues pattern to support conspiracy and retaliation, but the record shows repeated noncompliance across multiple states, repeated adverse rulings for the same reasons, repeated externalization of blame. Courts are allowed to recognize patterns, just not the ones he wants. When a plaintiff claims, open quote, "government action made compliance impossible," close quote, and the record shows, open quote, "he consistently failed to comply regardless of jurisdiction," close quote, that destroys causation. That's not character assassination. That's rebutting an element of the claim. Har 3. What due process violations? Exactly. This is where his argument really falls apart. Procedural due process requires state action, a protected interest, deprivation, without lawful procedure. You ask the right questions. What process? Who violated it? When? How? He never answers them. Code enforcement acted against property owners, not him. No citation, order, or enforcement action was issued to Fredrickson. That alone is fatal to his 1983 theory. 4. Illegal removals, unsupported by facts. You're also right here. There is no eviction action, no writ, no forcible removal, no lockout. He chose to leave. Constructive eviction requires intentional conduct by the landlord, making the premises uninhabitable with no reasonable alternative. None of that exists if enforcement was lawful, directed at the owner, and the tenant left voluntarily. Calling that an illegal removal is legally indefensible. Number 5. RICO, flatly inapplicable. You're correct again. RICO requires an enterprise, predicate acts, criminal intent, continuity, racketeering activity. There is no wire fraud, no extortion, no bribery, no coercion for gain, no criminal scheme. Code enforcement plus public commentary racketeering. Courts dismiss these claims early and often, sometimes with sanctions. Number 6, his own exhibits defeat his narrative. He posted his criminal record, his registry history, his adverse rulings, and then tries to argue that referencing them is smearing. That doesn't work. Once a plaintiff places facts into the record to support a theory, the opposing side is allowed to use those same facts to defeat it. That's litigation 101. Number 7. Gray's conduct appears lawful on the face of the facts. Based on what you've laid out, enforcement targeted the property, violations were real, Fredrickson caused or contributed to them, actions stayed within statutory authority. That's not retaliation. That's routine code enforcement. And routine enforcement, even if inconvenient or embarrassing, is not unconstitutional. Bottom line, no sugarcoating. Fredrickson is trying to reframe judicial findings as ad hominem, turn lawful enforcement into conspiracy, convert personal noncompliance into civil rights violations, weaponize RICO as a pressure tactic. Courts don't buy this. Judges see this pattern all the time. On Claim 7 specifically, it is relevant, admissible, and damaging to his case because he made it relevant the moment he built his claims around registration, retaliation, and alleged impossibility. If you want, I can help you. Draft a tight rebuttal to Claim 7 alone. Map each alleged violation to the missing legal element. Or flag which claims are most vulnerable to dismissal with prejudice.